Hello friends, Mandar here. I'm back with another video. Today we are going to talk about several topics that have to do with green card employment based. We are going to talk about what are the kind of jobs that you can do while your adjustment of status is pending. We are going to talk about EAD. There are specific questions about H1b and what can we expect to see regarding the priority dates in the next couple of months. So if you are in the process of green card, I highly encourage you to watch this video until the end and let's get started. If you are here for the first time, welcome. My name is Mandar and I make immigration related videos for US and Canada. Not an immigration lawyer, so anything that I say on this video or on my channel is for information purpose only. And for your specific immigration needs, before you take any action, you should hire a competent immigration lawyer. Now, I have been making a lot of videos that are specific to the topic, and every now and then I cover some important questions that I get through the email or through the comment section. So if you are stuck with any questions, be sure to ask them in the comment section because I do read them and I do try to respond to as many people as possible. Maybe I cannot get to every email, but I try to address as many as practically possible for me. So if you don't get a reply from me, just send me a reminder and I'll try to reply. Now this is one particular question that I got from a few different people. So you come with your spouse and your kid, and sometimes it happens that your life circumstances change and the spouses or the husband and wife are no longer together, and one of the spouse has started the green card process, but because of their change in the circumstances, now they are no longer together. So now the question is, can a dependent continue the green card application, and eventually can they get their EAD, green card or citizenship? Now let's break it down to few different sections. First of all, let's look at non-immigrant visa. So if you have a primary applicant who is on HL or those sort of visas, and if there is a dependent who is on H4, L2 and so on, the dependent visa is practically based on the primary visa, the primary applicant visa. So if there is any problem in your staying together or your marriage, and if it's no longer valid, technically you cannot be as a dependent. So now the USCIS will not automatically come to know that you are not a dependent, but in reality you might be breaking the law. So be careful, consult with a lawyer. If you are on a non-immigrant visa as a dependent, you might want to leave and come back on some different visa if you are no longer with your partner. So that is something to keep in mind. The second question is, if you have a green card petition filed by the primary applicant. So say for instance, there is 140 is approved and you are in the 485 stage. And now if something happens to your partner and you no longer are with them, in this case you have to be careful, because the mere fact that you are a dependent as the primary applicant and you haven't yet received your green card, you have to be careful, because now if there is no marriage left, if there is legally, if you are not a dependent of the primary applicant, then there is going to be an issue with your 485. Now that is the thing. There are different ways you should work with a lawyer to get onto a different visa, maybe a student visa or maybe a visitor visa, or have your own H1b filed. That is also an option. But technically, as a dependent, if you have stated that you have married and you are no longer married, then that could be a problem. So that is something to keep in mind. Now once you get a green card, and then if you have separated from your spouse, then you are no longer dependent on your primary applicant, even if that primary applicant was the basis of your green card. Once you get a green card, you are totally independent technically. You can apply for your green card extensions, and you can also apply for citizenship without the primary applicant. Believe me, in this day and age, people are facing this scenario as well. Now let's look at the second question. Now second question is the correction to my previous video. In my previous video, I mentioned that the green card EAD that you get for the first time is only valid for 1 year, and that was true. And that was true. There has been no change in the law, but I think there is a change in the policy, because a lot of people have reported to me that they have started seeing the first time EAD getting a validity period of 2 years, and this is very recent. Even just 2 or 3 months back, people were still getting an EAD which was only valid for 1 year, but now they have started seeing 2 years. Now you can look at it in a positive way, and there is a slight negative twist to it. The positive side is you don't no longer have to apply for another extension within a year. So now you have a 2-year validity, so you can relax and you have a longer period of time. Maybe you can even get a green card. But the negative side of this is this really gives an indication that USCIS acknowledges that your green card processing is going to take longer than expected. So even if you are in the 485 stage and you have your EAD, and if your date is current, you may still be waiting for at least 2 years, and that is what they are probably thinking, that let's make a policy change, let's start giving out 2-year validity EADs, so that there is a less burden on the National Visa Center and then the office that issues you an EAD. So that's just my thought on it, but it's a good news for a lot of people, because now you don't have to apply for an extension within a year. And just a reminder, particularly for a green card EAD, even if your first EAD is set to expire or expired, you can continue to work for your employer for up to 180 days, given that you have applied for your renewal of EAD. So if your previous EAD expires, you can still continue to work for 180 days until you get your next EAD. But if you cross that 180 date, then you have to be careful. Technically you're not supposed to work after that until you get your renewal green card, renewal EAD. Now there is a provision where you can expedite the EAD officially on the USCIS site. I will probably put the link in the description for that. But if you think that your EAD is taking longer and you are on the verge of losing your job, you might want to avail that expedited feature for getting your EAD. Now there is another question regarding what kind of job you can do while waiting on your green card. So your adjustment of status stage in reality gives you a valid status even if you don't have any other visa to go with. So your 485 pending status is a valid status from USCIS. You don't have to worry as long as you are still waiting for your green card. Now during this time you also get an EAD. Now technically in EAD allows you to work for any employer within the United States for a valid job. Now you would one question is, can I work for corp to corp on 1099? 1099 is a form that is given by your employer if you are earning an income on an hourly basis or a contract basis or things like that. So that is kind of a commission, or there are a lot of 1099 that you can get from your employer to file your IRS tax returns. So technically on EAD you should be able to work on corp to corp or 1099 because you are not violating any rules for something like H1b where you have to stick with your current employer for a W2. That is not the case with EAD. On EAD you can work on 1099. But remember, when you come to the final stage of green card, when there is a decision to be made on your 485, that is based on your I-140 job profile. So if you have changed industries or if you no longer work in the type of job that you have mentioned in 140, then you are misrepresenting yourself for the purpose of 485 application. Remember, you also need to have a bona fide job offer that is matching your I-140 job description. So basically you need to have your job offer lined up at the time of your adjudication of 485. So that is something that you need to kind of keep in mind. Now in the past couple of years there have been an interview which would actually prompt the USCIS officer to go through your current job and all. So that is no longer happening because there are no interviews. So there might be cases where USCIS may not even look at what you are doing currently and then just issue you a green card, but expect to see an RFE for supplement J if you haven't provided with the job change with the AC21 rule. You can work different jobs in between, but at the time of adjudication your case will be approved as per the job profile described in I-140. So that is something to remember. Now again, I also covered the topic of whether you can go outside the United States to work while your I-485 application is pending. I have cautioned everybody in not doing that because that may impact your case. If USCIS gets the wind of you not being present for an extended period of time within the United States, or you have changed the job, or you no longer work for the company that you mentioned on your 485, then that is misrepresentation, plain and simple. So you are taking a risk if you are going out and working extensively out of country while your application for 485 is pending. Now there have been a lot of questions regarding what is the progression of dates we can see in EB2 or EB3 India. Now as I mentioned in my previous video, we can expect to see 4 to 6 months of progression for EB2 in August visa bulletin and September visa bulletin. Technically the dates in the final action date chart should be coming as close as possible to filing date chart. Now we have seen Charlie progressing the filing date chart dates as well, so he may do so as well in the next month. Even if that happens, then you have even further progression for EB2 and EB3. So say for instance, if you are looking at the July 2021 visa bulletin, and if you come down to final action date chart, EB2 stands at June 1st 2011 and EB3 stands at January 1st of 2013, and if you come down to filing dates chart, EB2 is at 1st of December 2011. So there is a difference of around 7 months for EB2. I am expecting that Charlie might even progress this date to say 2012, middle of 2012, or maybe a couple of months into 2012. So if you calculate, the August visa bulletin should go somewhere around October to November of 2011, and September visa bulletin for EB2 might go into 2012. Now which particular month, I would say around March to April of 2012. That's for EB2 India. Now for EB3 India, as you can see, there is 13 months of progression left. Charlie might even extend this to May or June of 2014. And if that happens, we can see an extensive progression of 7 to 8 months in August visa bulletin. So say for instance, up until September of 2013 for August visa bulletin, and about June of 2014 for September visa bulletin, and that's for EB3. So that's my pure guess. In October visa bulletin, we should see couple of years of progression for filing date chart. I'm going to make a special video on what dates to expect for October 2021 visa bulletin for EB2 and EB3 India. So watch out for my channel. I will be posting that video anytime next. Now there is a question regarding H1b, whether or not you should file amendment if you have been working from home and not your office location that was posted on your LCA. Now here's the thing, any material change to H1b such as salary, job title, job duties, location, all of these are material change to your H1b, and you are supposed to file an amendment. Now you don't have to file an amendment if you are living within say drivable or commutable distance from your office location. So if your office location is the address that you have on LCA, and if you have been working from home that is within commutable distance, then technically you don't have to change or amend your H1b. But say for instance, if you are outside the radius of say 50 miles, but say if you are outside the radius of say 50 miles, which is longer than a commutable distance, then you should file for an amendment. That is just a clarification that I wanted to give regarding one question. Now there is a lot of confusion between how do you maintain your H1b versus EAD or advanced parole when you travel outside of the United States and come back. So remember, if you travel outside of the United States during your I-485 pending status, and if you have a valid H or L stamp on your passport, you can come back on that status and still maintain that status, and your I-485 will also be intact as long as you come back within a reasonable time frame. Now if you come back on EAD AP combo card, EAD has nothing to do with your entry status. AP is advanced payroll is the document that you need to come back, and that is actually on the combo card. So it's at the bottom, you'll see that it's also valid for as advanced payroll card. So when you come back on advanced payroll card, you will be DA entered. You will be undergoing a secondary inspection at the port of entry, where they will ask you certain questions, and basically it is to validate that you have maintained the terms of your parole. So basically they will check your I-485 application is still in progress and you haven't violated your advance parole or travel conditions, so you have come back in a reasonable amount of time. So those are the two critical things that they check, and they also check if you are admissible into the country, so you haven't committed any fraud or felony or those sort of things. So once all of those things are good, then you are allowed into the country as a parolee. And if you look at the status on your I-94, it will say DA entry. DA is District Attorney entry. So that is the status online officially on USCIS. So after you come back on AP or advanced parole, you no longer have H1b. So technically you are not on H1b status. At that point you are on a DA entry or parolee status. Now that does not mean that you cannot use H1b. You can choose to use EAD coming back and give your EAD as I-9 to your employer and work on EAD. Alternatively, you can also ask your employer to refile your H1 in premium, which will come back in 15 days. So in the meantime, you can start working on EAD, and once you get your H1, that H1 will be reinstated for you. So that is another option. So I just wanted to clarify this point. Work with a lawyer if you have still more questions, or send me an email or put in the comment section below. And then the last question is, there is going to be about 100k visa wastage. How do you think that will impact the October visa bulletin? And I'm going to make a special video on that. So subscribe if you haven't, and hit that bell notification so that you get a notification when I post that video. So that's all I wanted to cover in this video. If you got value out of this video, please hit the like button and consider subscribing to my channel, and I will see you in the next one.